Welcome to another conclave session. For today's our topic is employer-sponsored visas. I would be covering all of the employer-sponsored visas which are there. As an introduction, I'm Preeti Puri. I'm a registered migration agent with Aussizz and I'm in the Perth office. I would request everyone to put your or give the comments or all your questions in the chat box. And during the end of the session, I'll be taking all of the questions. Now, to start with this, today, as I said, we are going to cover the topic for an employer-sponsored visas. All the visas that I'm going to cover, that's going to be the 482 visa, which is known as TSS. Employer-sponsored visas 186, which is the permanent residency. Regional sponsored visas 494. Also, I'll be touching about the 407 visa as well as the DAMA. Now, let me first talk about the employer-sponsored visa subclass 482. This is a temporary visa which may or may not lead to the permanent residency, but in a short, it is basically a temporary visa. And while you are holding this visa, you can be eligible for the residency in few circumstances, which I'll be covering later in the slides today. 482 visa has got 3 stages. One is the sponsorship, then is the nomination, and last is the visa application. You do not have to wait for the sponsorship or the nomination to be approved to lodge a visa application. All of the 3 steps can be lodged at the same time. However, the the sponsorship is to be lodged first. Once lodged, then the nomination, and then the visa application. So the first 2 stages, which is the sponsorship and nomination, that revolves around the employer only. It has got all the details about the employer, about the company and everything. It's the last stage of the visa application, which revolves around the education, experience and everything required by the visa applicant. So the first stage, as I said, is a sponsorship. Mainly the department is looking towards that the business is lawfully and actively established in Australia and has got a sound financial positions. The SPS is approved for 5 years. There are 2 kinds of SPS. There is an accredited or a non-accredited. Most of the companies have a non-accredited sponsorship. The accredited sponsorships are the ones where at least 80% of the staff is an Australian, where the visas has been granted in the last 2 years and there has been no adverse information. So to be an accredited sponsor, the sponsor must have hold one sponsorship which is non-accredited first and have met with all the conditions before applying for the accredited one. To show that business is lawfully active, one needs to provide the ABN, ACN, the trust deed, the lease agreement. It doesn't matter whether the business has been just newly opened or it has been established from years ago. That's not a condition that business must be at least 12 months trading or something. If it is a newly established business, we say that you can provide the lease agreement, something like your details about the plans, the detailed business plan, that how the business is going to operate and what are its operational structure is going to be. If it is a retail business, you can provide the bank statement, which has got a daily FPOS things in it. So it shows that it is actively established. And if, let's say, the BAS is not available and it has been just running from the last 1 or 2 months, the business activity statements are not there, then the bank statements and the leases are the one. There's no requirement that the business should be established for more than 12 months or anything. Generally, the obligations for an employer is they have to cooperate with the inspectors with an SBS once that's approved. Every now and then, a department can always go with the inspections and The sponsor has to make sure that all the records, what's being asked for, has been provided. The stage two is about a nomination process. Nomination is something which is the most important and the backbone for the 482 application. If the nomination is not approved, the visa will not be granted or will not be approved. It is mandatory to have an approval of a nomination first before the visa could be even assessed by an officer. The requirements are, let's say that we have lodged a sponsorship and lodged the nomination. So the sponsorship must have been approved, and that is on the basis of if a business is actively operating. Then the requirement is there must be an occupation which is in the 482 list. So there are two kind of 482 list, which is the long term or the short term list, MLTSSL and STS1. So I'll be talking about what's the difference between those two in my further slides. But for lodging a nomination, you just only have to choose an occupation, and the application will itself pick it up, whether it's a long-term occupation list or a short-term occupation list. Then the most important is the labor market testing, which includes the advertisement of the position. The position must be advertised at least for 28 days in the three mediums. The three mediums, out of these three mediums, one of the mandatory one is a Workforce Australia. What is the Workforce Australia? Is the government website where the jobs can be placed. So it is mandatory that the position must be advertised in a Workforce Australia. In addition to that, there must be two more mediums. That can be Seek, that can be Indeed, that can be Career One, or any other job portal which is nationally available. There's no such requirement that the other job portals must be paid or unpaid, but that must be only for the recruitment purposes. Jobs in some things like Gumtree is not acceptable. It should be a national job portal which is available for the employer and employees to look for the candidates or look for the employers or vice versa. So do not put any advertisement in the job in the country. And now the more important part for the LMT is that it must be advertised at least for 28 days. And after that, the employer must give itself at least 7 to 8 days to undertake the recruitment process. So let's say that I have advertised the position today, that is 8th of July, and after 28 days, which is probably maybe 7th, 5th of August, we have finished the 28 days, and the next day I lodge the application for a nomination. This could lead to a refusal or could lead to a doubt to the case officer that the LMT has not been done properly or is not taken as per the aspects, because once the LMT is finished, then you have to take the interviews, then have to offer the position that's been accepted. So generally give yourself 4 or 5 days for the recruitment process after the LMT is finished. The employment contract, which is offered to an applicant, must be after the LMT has been completed. So if the LMT has been completed today, employment contract is just given the next day, it clearly gives a doubt to an officer that the nominee was looked into even before the LMT was finished. This is to look forward that the Australians or the permanent residents has been offered a position first or has been looked forward for, and after that only any foreign national has been offered a position. So always give at least 7 to 8 days after completion of the 28 days of an LMT, and the employment contract must be dated accordingly. The position, now the next requirement is that the position must be genuine and available full time. The full-time availability is minimum 35 or 38 hours, depending upon an occupation. And must be genuinely towards the industry for which that occupation is. So if it is a restaurant, then definitely a cook or a chef or a manager is a genuine position. But if it's a restaurant with just 7 or 8 people and there are not no more any branches, and if it's a position of an accountant, that could create a doubt to the department or to the officer again that it is just created for the immigration purposes and is not genuinely for the applicant to work here, or there is a profile for a work which we could show that 38 hours a week, 8 hours a day, what an applicant would be doing. So the job description is must be highly relevant to the position, which must be genuinely available to the company and has been acquired for. The employment contract which is offered should be of a market salary rate. Now, what's that is market if either market salary rate is determined by two ways. Number one, that if there is an Australian or a permanent resident in a full-time position already working in a similar role, then whatever is being offered to an Australian must be offered to the applicant or to the nominee also. This is to avoid so that they are not being offered the lesser salary just because the employer is sponsoring them. And it must be above the TISMET level. The current TISMET level is 53,900. If there's no Australian that's working, then we look for the job applications or we look for the advertisements for the similar position that has been within that range has been done, and whatever salary has been offered to that, then we make an average annual market salary rate. And that's important, and that must be done rightfully again. Again, the one of the last requirement is that there must not be any adverse information about the company, and these adverse informations could be anything which could be from an ATO, which could be from the Department of Home Affairs, which could be from Fairworks, which can be from the legal aid, could be anything. So the department should not be aware of any of the adverse information. So putting the nomination application is very important, the right way. And the processing time for a nomination currently is between 2 to 3 months. Once we have lodged the nomination or it is approved, then it goes to the visa application. For a visa, it's a straightforward thing that the applicant needs to be for an eligible sponsor and an approved nomination. Once those two stages are done, then the visa can be looked into by the case officer. The applicant needs to meet the skills and qualification requirements. For the skills and qualification, it is required that the applicant must have at least 2 years of a full-time experience within the last 5 years. Part-time experience is not considered. It does not need to be post-qualification. Some of the experiences can be while you have studied, but it must be at a skilled level. And the duties that you have undertaken is closely looked by, and this can only be shown by the experience reference letters that your employers have given. And this experience does not need to be with the same employer who is sponsoring you. It could be any employer, can be an onshore or an offshore experience, but must be held within the last 5 years. Another requirement is to meet the English language. For an English language, the applicant can meet that by 3 different ways. First, they can sit for an IELTS or a PT or any equivalent test and score minimum 5 each in English. Okay. Or the applicant can show he or she has studied 5 years in an English medium, which is post-secondary school onwards. So from year 7 to year 12, if you have studied, you can provide a letter from your school stating that you have completed your year 7 to year 12 from the school and the medium of instruction was English. Another way is any Australian diploma. If you have completed, you are deemed to meet the English requirement. Or you have done a bachelor's study which was in English medium in your overseas home country. Then also you have met the requirement. So either you have to sit for an English test, or you have to show you have studied in English with minimum 5 years of a post-secondary schooling or bachelor's or the diploma level Australian qualification. In other words, or the applicant is a passport holder for one of the 6 countries, which is considered at 6 each for the competent English. But you cannot pay for a second VAC to meet, because the second VAC is only equivalent to a functional English. However, here you need a competent English, which is 5 each. In addition to that, you need to meet your health and character requirements. We always advise the applicants to upload their PCCs and the AFPs. AFP is an Australian Federal Police Check, and PCC is a police clearance from the home country. They must be available on your application to have a quicker processing. Once the nomination is approved and all the required documents are there in your review account and they have been uploaded, it is a decision-ready application. You would see that the application will be processed both the stages at the same time. The good part is there's no age requirement to apply for a 482 visa. You can be of any age and the 482 visa can be applied for. Once the visa application has been granted, there has been an obligation for a nominee or an applicant to week 4, and that is they can only work with the approved occupation. If you have been approved with the employer as a chef, you cannot work as a restaurant manager. You have to be in your approved occupation. You cannot work for any another employer even while working in that position. So even if you are a full-time employee and after that you want to drive an Uber, you are not allowed to. You cannot work anywhere else. You cannot cease your employment more than 60 consecutive days. If you do that, you have to look for another employer. If it is a registered occupation, you must hold the mandatory requirements and comply with the license requirements also. So now I talk about, so this was the primary criteria or the common criteria for any 482 SBS nomination and visa. Now I will be talking about the 3 different streams in which the applicant can apply for a nomination and a visa. The first one is a short-term stream, another one is a long-term stream, and then comes the labor agreement. The short-term visa comes with 2 years, medium-term and long-term come with 4 years. The short-term visa, the occupation is in STSOL list, which is the short-term list. It can be renewed for three years onshore, so you can have up to 6 years. However, before the 1st of July this year, it was only to be renewed up to 2 times. For the 3rd time, it is only for an applicants who were already in Australia during the concession period, and the 3rd renewal can be come out of the concession can be any time. Now comes the medium term. The difference between the short term and the medium term is basically the occupation list, and you can get the visa up to 4 years. And depending upon the employer, if he's happy to sponsor, there is no obligation. Employer can sponsor you for a TRT ENS, which means the permanent residency. In few cases, for the short-term holders also, they can lead to a permanent residency, which I'll be covering in my later slides today. The third stream is a labor agreement stream. For labor agreement stream, we do not have to go through a process of an SBS nomination and all that. This is because there is no list for a labor agreement stream. This is for the people where, let's say, an employer wants to sponsor an occupation which is not neither in a long term, nor in a short term, nor in an ROL list. In this case, they have to approach the department and have a labor agreement and have to get a position approved first and then can apply for the nomination and further the visa. So instead of an SBS, in the labor agreement stream, we have got to get the approval of a labor agreement first. The employer has to identify why there is a skill shortage and what positions they need. What efforts have they made to look forward to employ the Australian citizen or a permanent resident? For a labor agreement, we could always negotiate on the basis of an age, for an English, for a education, for a skills. We can apply for the concessions that we are looking for the applicants we are not able to get, and we need to, instead of 2 years, we are happy with having a 1 year of an experienced candidate also. So once these negotiations are done and labor agreement is approved, then only the nomination can be lodged. Unlike the 482 long-term and a short-term stream where SPS and nomination can be lodged without any approval also. I mean, does not need to be approved first to lodge the nomination. Now, this is a very common question which everybody asks for. Can a 482 visa lead to a permanent residency? If you have got your occupation in a long-term list, then surely it leads to a permanent residency as a 186 visa as per the TRT stream. However, the employer has got no obligation that the 482 holder must be sponsored for the 186 visa. For the short-term visa holders also, there have been few, and I'll be covering that. So, in a nutshell, for an employer-sponsored visa, the first thing that we do is we apply for a sponsorship. And once the sponsorship is approved, even if we have applied before or after, then we can apply for a nomination before the approval also. And after the approval, then it's the visa. And then the visa applicant can work from 2 to 4 years, up to 4 years, depending upon the list, which is for this one. So this was the details about the 482 visa. Now, my next slides, I would be covering about a 186 visa. Now, 186 is also an employer sponsorship. This also leads to the permanent. It is a permanent residency. It doesn't lead to, it is actually a permanent residency. And for this also you need an employer, and it allows nominee and its family to work in Australia. You get all the permanent resident benefits, what you get in any other skilled visa. There is an age requirement for this, and that is 45 years of age. For a 186 visa, there are again 3 streams: direct entry, TRT, and labor agreement. Now, for a direct entry stream, if the employer or if the applicant has not worked with an employer but has got the requirements to meet the visa requirements, can apply directly. It doesn't need to be that they should have worked with the employer. All the applicant that needs is to have a 3 years of a full-time experience and a full skills assessment. If the applicant has got these 2 things, they can apply for a 186 visa straight away. They do not have to first work with the employer and then apply. Then comes another one. Another stream is the TRT stream, temporary residence transition stream. To apply under this one, the applicant must have held for 3 years 457 or a 482 or a combination of these two visas and have already worked with an employer for 2 years in the last 3 years on a 482 on an MLT SSL list, or for 3 years in last 4 years. Okay, so it all depends upon when was your 457 visa granted. If your 457 visa was granted before 2017 March, 18 March 2017, then you need 2 out of 3 years. Otherwise, you need 3 years to work with an employer to apply for the under the TRT stream. You do not need to have a skills assessment. You only need to show the working with an employer. So that's the basically the difference between the direct entry and the TRT, which is mainly about the skills assessment and whether you have worked with the same employer holding the temporary visa or not. Then comes through the labor agreement, where we have already talked about the labor agreement when in a 482 visa, when you're holding a visa for a 482 under a labor agreement, that leads to the 186 visa under the labor agreement after working for 3 years with the employer. Now, requirements for a direct entry. As I said, there is an occupation list for a direct entry. So your occupation must be in that list. It is not a very vast list. There are still quite a few of a good number of occupations which are critically needed by the employers. And so you can apply for a direct entry for this. Applicant needs to have a full skills assessment, competent English, which is 6 each, and 3 years of a work experience in the occupation. If you have that, then you are all good to apply for ENS under direct entry. Now we talk about the TRT stream. Under the TRT stream, the employee must have worked for 3 years for the sponsoring employee while holding a 457 or a 482 visa. We talk about the permanent residency requirements for the TSS 482 short-term visa holders. There's a new change that allow access to the TRT holders for the ENS from 1st of July for short-term visa holders. Now for those ones, this is the one who have spent cumulative a 12-month of a period in Australia between February 2020 and 14 December 2021. So let's say that during when the borders were closed, you were in Australia and today you have got an employer who can sponsor you for a 482 visa. Then and it is under the short-term skills, then you can still lead to the permanent residency. So this concession is only available to the people who were holding or who are going to hold a 482 visa now. Even if you apply now, you were in an Australia, you were not working with that employer, you were not working in that occupation also, you can still be eligible for the 1 in 6 TRT under this concession. Now we talk about the 494. This is another visa, which is the regional permanent residency. For this one, you need to have an approved RCB. Every region has got their own RCB, and RCB has got their requirements that you must be offered a position at a market salary rate, and you must have undertaken an LMT. Every employer needs to have an RCB approved in order for a nomination to be approved. These two applications can go in parallel. You do not have to have an approval first of an RCB in order to lodge a nomination. Rcp nomination criteria is again a genuine need of a paid employee. So the position must be relevant to the industry where you have been applying for. There has been a market salary rate and the employee has been offered that, and the position was not able to be filled by the local market. In order for an employee to meet the requirements of a 494 visa, they must have got a skills assessment, have completed 6 each in English, and have got a 3 years of a full-time experience. Now, but the 494 visa is a provisional visa. So it's the same requirement what is there for a 186 visa for an applicant. Then why an applicant should apply for a 494 when there are the same requirements for 186? That all depends upon an occupation list. If your occupation is not in a 186 list, that's why we look forward for applying for a 494. Once your 494 visa is approved, you cannot change your employer. You have to work with the employer for 3 years and then can apply for the permanent residency, which is the 191 visa. You must have to apply for us. So 494 is basically to get the permanent residency. It's a two-stage process. Firstly, you are doing a 494 visa, which is a provisional permanent residency. This visa is granted on the basis that you have got a 3 years experience as well as a full skills assessment and 6 each in English. Then you apply for the visa, your visa is granted. You need to work for the same employer for 3 years. Or if you're changing an employer, then again you have to apply the nomination again, not the visa, and whatever work accumulative you have done with 2 employers, that should be equivalent to 3 financial years, and then can apply for the 191. The difference between the 186 TRT and the from 494 to 191 is when you're doing the 186 TRT, that you are a holder of a 482 and applying for the permanent residency, your employer needs to renominate you. You need an employer to nominate you. When you're applying for a 191, you don't need an employer to nominate you. You only have to show that you have worked with your employer for 3 years. So there is no nomination application in a 191. It's only from a 494 visa to another 191 visa application. So you do not need to be applying for a nomination again. You must have earned minimum 53,900 for 3 years on a 491 visa and must comply with the 491 visa conditions, which is to live and work in a regional area with your employer for 3 years. In case your employer business is closed, then you need to find a new employer within the 60 days, apply a nomination, and start working with them. So if I worked with 1.5 year with one employer, and then I move to another employer and work for another year and a half, then those two can be counted towards the 191 residency. You can add your family member even after the lodgement of an application also. The child needs to be under 23 years of an age. The spouse also needs to meet this English requirement for a 191, which is the functional English 4.5 overall. The benefits of a 191, it's a permanent residency. You get Medicare after at the time of 494, you get the provisional Medicare, and then you get the full Medicare once you hold a 191. You can sponsor someone and you can apply for a citizenship. When you're holding a 494, you cannot sponsor your relatives or you cannot apply for a citizenship. So now we have covered the 482, the 186 under the labor agreement, direct stream or TRT, and a short term, and the 494. Next, I would be covering your another kind of employer sponsored visa, which is 407. This is for the visa. This, let's say that I have got an employer who's basically happy to sponsor, but I don't have much of a work experience. I don't hold my 2 years of an experience. Then we can apply for a training visa, 407 visa, where the employee is basically, you need a supervisor who's training you, and there is a structure program which is on the job training. You are learning while working and can be applied for this one. To apply for this visa, it can be granted for up to 2 years. So we could use this visa if your occupation is nowhere in any other thing and you can't apply for any other thing, then you can go for a training visa, hold this visa for 2 years, apply for a 482, and then further either the 186 or a 494, depending upon your occupation, and you can be eligible for this. The eligibility criteria to apply for a training visa is at least 18 years of an age, and you would need an SPS application also for a training visa, that employer is lawfully operating a business in Australia. You need to have a nomination approved that under what occupation is the employer going to train you, and you have you have been invited by the government for this. For a visa applicant, you need to have a functional English, which is 4.5 overall. You need to have at least 1 year of an experience in the last 2 years, or must have undertaken a study in which you are going to be sponsored within the last 2 years. So, for example, I've done accounting, and my study has been finished within the last 18 months. I don't have any experience. I don't have enough points to be eligible to get the state nominations or a 189 visa, or I don't have an English so that I can get my skills assessment even done. So I could probably go on to a training visa because my studies have been finished within the last 2 years. There's an employer who is happy to make me skilled. There's a supervisor who has got the relevant qualification or a degree who could supervise or train me, and we could apply for a training visa up to 2 years, showing what I'm going to learn within this training visa. Once you get your 2 years of your experience onto the training, you could apply for a 482 or you could apply for different other ones. There's a question about can we use the experience gained on a training visa as a skilled employment? That all depends upon what was the level of the skills or the complications that you were learning. If you're learning a very basic about your skills, then we will not. Let's say I already have about 7-8 months of an experience and I have studied in accounting. Now I'm learning the complex cases of how the accountant works within the organization, where there are the complex cases for determining the eligibility of the company and doing those ones, then yes, we could definitely take that as a skilled experience. So depending upon during the training what we were learning, whether it was a complex or whether it was the basic structure of this work. Or maybe the first six months or 1 year you were learning the basics. So when we are making a training plan, because that's the requirement of a 407, we are submitting a training plan. We can divide that training plan within the 6 months of each. And within those 6 months, we could say that the first 6 months we were doing very basic and then a little advanced and then the advanced and complex. So the first year, I may not claim any experience for that, but the later I could. Sorry, these are the repeated ones. So that was about the training visa, where you have hardly any experience or within the last 2 years, or I have started for this one. Next, I would be covering, that's the DAMA. These are the labor agreements. This is again a kind of a labor agreement which has already been negotiated by your council, by your region, and the occupations has already been included in that list. So there are these are the current Dharma which are available, and that's the Goldfields in Kalgoorlie. There is in Northern Territory. There's one in Victoria, South Australia, Orana, far north Queensland, and there's one in the Pilbara region which has been recently negotiated also. These dharmas lead to the permanent residency. So this is again a kind of a 482, not a kind, it is a 482 visa, where the labor agreement has already been negotiated with the council, and the occupations has already been identified that these are the occupations which is needed by this region, The skills, there can be a concession in skills, age, English, that in a normal 482 we need 2 years of an experience. In this we may only need an Australian qualification, or for it, or 1 year of an experience, or either. It is very good for the people who are even offshore to get those ones, or their occupation is not in any list. For example, fruit picker, for example, truck driver, retail supervisor, childcare worker. We do not have these occupations in any list, but there is a shortage of these ones, right? And assistant nursing or aged care worker. These are very important occupations, but not in any list. So we can find an employer who is in a Dharma region, and we have to look for, every region has their own list. We look for an occupation. The concession requirements are quite flexible, and then you can apply for a 482 visa under this one. The Dharma also leads to the permanent residency. After working with an employer for 3 years, you can apply for 186 or a 494 visa, depending upon what is being negotiated in the agreement. The requirements for the Dharma, that you must be nominated by an employer. So if your occupation is in a Dharma list, but you don't have an employer, then we don't have to get happy for that, because we need an employer who can sponsor. The occupation must be in that specific list. So for example, you have found an employer in Kalgoorlie, but the employer is not there, but the occupation is not there in the Kalgoorlie region, then again you can't. For example, a retail manager or a supervisor was there in the Kalgoorlie list, but not anymore. So you cannot be sponsored for that. You need to meet the English requirements. There could be concessions, and most of the Dharma occupations have got the concessions for an English, for having a functional English maybe, or maybe 5 overall rather than a 5 each. Again, the TISMET needs to be met, and the market salary rate needs to be met. When we talk about the Dharma process, the step 1 is, instead of an SBS, we have to apply for the endorsement with that region. The region who has negotiated with the department, we apply for an endorsement that within that region, we need, this employer needs this occupation. For example, a baker, we need it, and then they can apply for an endorsement. For a couple of different occupations, only one endorsement can also go. You do not have to apply for each occupation a different endorsement. For example, I have a company, and I need a baker, I need a retail, and it's a retail shop where I need a retail manager and a supervisor and a baker. So I can only apply, I need to only apply a one application for this, and can get approved all of these nomination, all of these endorsements. I can get it endorsed. Then we go with the labor agreement, and then with the nomination. Nomination is for each application or each position, and then goes for visa, which is for each application and each position. So endorsement can be one application, because that is by an employer that I need these positions. And then they identify a nominee and apply for that as an individual nomination and an individual visa application. Once you have got your 482 visa approved, then as a last step, you apply for the 494 or a 186 once you have worked with an employer for 3 years. So again, the Dharma leads to permanent residency, but you must have worked as a holder of a 482 visa with the employer for 3 years. Now I'm going to talk about the recent changes which has come, and I've made some frequently asked questions about this, which should cover most of your queries. Are you eligible for this new change of a TSS 482 short-term visa, which leads to the permanent residency? This new visa 482 change does not apply to all TSS 482 short-term visa holders, okay? Especially who just got their 482 visas granted offshore and came to Australia after the borders were open. So what does it mean? Let's say that I have applied for a 482 visa now, and then I was granted offshore. I was not in Australia for the period of 12 months when the border was closed. Then I'm not eligible to, under a STSOL, to apply for the 482 visa. So if you were in Australia for a period of 12 months between February 2020 and December 2021, and so it is for 12 months, it's there, and you are employed by a suitable Australian employer on a 482 visa, and you have been granted this 482 visa now, then you are eligible. But again, you are granted a 482 visa now, but you were not in Australia for the 12 months during this time, then you are not eligible to apply for the TRT under the STSL list. So even if you were not holding a 482 visa with that employer, you're still eligible. But you must have been in Australia, whether you were working with the same employer or not, whether you were working in the same occupation or not, doesn't matter. It just only needed that you must have been in Australia for 12 months between February 2020 and 14 December 2021. And now you are holding a 482, which you were either holding a 457 before or holding a 482 now, or now going to apply and will be granted after 14 December 2021, doesn't matter. Then only you are eligible for the TRT. These changes have come into an effect from 1st of July 2022. So the short-term visa holders who were already holding a 482 visa and have finished working with their employer for 2 years or 3 years, and they were in a short-term list. Earlier, they were not eligible to apply for a PR. Now they can also apply for the permanent residency after the 1st of July, which is into effect now. If you were holding another visa during the concession period and not working in the current occupation, what's the circumstances during this? You're still eligible to apply for TRT stream, because they only said that when you apply, you're holding a TSS in a short term, so you need to apply for 482 now. For a period of 12 months, you are in Australia between 1st Feb 2020 and 14 December. And it does not mention any requirements related to employment status or a visa subclass, which the applicant was holding for that 12 months. So, but we also have to consider that this is what they are talking about is until 2025, this arrangement is going to be there. After that, if this concession comes out, or if they say that you cannot. So let's say that I have an employer who may sponsor me after 1.5 years. I was in Australia during this time. My employer is going to sponsor me in January 2023. I'll be completing my 3 years in Jan 2025, or maybe because your visa takes 2 or 3 or 4 months for processing, I will be completing in maybe June 2025. This is only available until March 2025. So we have to be ensured that currently when we are going to be lodged, it is going to be a very quick one, because we don't know whether the concession will go beyond the 2025 or not. How long do I have to work for a 482 or a 457 visa to comply for a TRT? Most applicants looking to take advantage of these new changes will need to work for 3 years. So once you work for 3 years, there is a concession done for 2 years who have already hold a visa for 457 on 18 April 2017. And they are currently also holding either a 482 or a 457 visa. So definitely they might not be holding a 457 because it was granted at that time. So if they are currently holding at that time, then they only need to meet the 2 years, not the 3 years requirement. Now, I think I've covered whatever is all about all the employer-sponsored visas, which were the 482, ENS 186, direct entry, TRT, 494 visas or training visas, and a DAMA. I would be taking the questions, which is from the chat box now, and we'll be taking it from the first question. Let me come down to this. The first question is from Sagar, and it says that as an undergraduate, I worked casually in a company related to my degree for 2 years and will now change to a full-time after I graduate. Can my employer sponsor me? So let's say that you want to get sponsored for a 482 visa. You said you have worked casually, and those casual work, if this was an ongoing, regular casual, then can be considered on case-to-case basis. But if I have just done one shift and then after 3 or 4 days, another shift, and then 2, 3 days later, another one, and it is not an ongoing, regular casual shifts, then no, then you need to have 2 years of an experience to be sponsored under the 482. However, in this case, because you have been recently graduated, you can even apply for a 407 visa also, go on to that, gain your experience, and then further can get the different other visas. Next question is from MS. How to find out that the company is approved sponsor? My occupation is accounting and the employer wants to sponsor me after 3 months of me working with them. However, I'm scared that after 3 months, if employer flip, then what to do? Um, Look, to approved sponsorship, your employer can only tell whether they have got an approval of an SBS or not, because there is a, like you get your visa approval, you get the letter. That's how an employer gets an approval. And if your employer is not going to sponsor you, then you need to look for the alternates. I'm sorry, I will not be able to help you out with this. Next question is from Mary. Hi, want to know if you get approved or granted 482 and then apply for 190, 491, do the migration department still prioritize the 190, 491 application, though you have a sponsorship visa? Your current visa does not matter about your processing of your 190 or a 491 application. You could be that these are the completely two different aspects of it. They will be processing as per the global standard processing time. Next quiz, Abigail. I'm 45 years old, going to study Master of Social Work. Will I be eligible for a post-study grad visa after? Then will I be eligible for employer nomination visa? How do I know if the company I'm applying to can sponsor? Is this posted somewhere or this can be personally asked? Okay. Now, Abigail, you are going to turn 45. Then you are going to start your Master of Social Work. Then you will be eligible to apply for your 485 visa until you turn 50. Most of the permanent residency visas need applicant to be under 45. So unfortunately, you won't be able to take an advantage of a 186 visa, or you can only be sponsored for a 482 visa because there's no age requirements for that, or can be sponsored under a DAMA, which can only lead you to permanent residency, because because DAMA also have got few occupations which have got an age concession up to 50 or 55 years of an age. So you can look into that, but need to find a DAMA, an employer in the DAMA region. If you are on a 482 visa, you can keep renewing your visa for 4 years and 4 years and all, but you won't be able to apply for a 186 TRT, even though you have worked with an employer for 3 years, because to apply for that, when you were holding a 485 visa, sorry, 482 visa, you must have been below the age of 45. Next question is from Mary again. Can I apply for 190-491 without meeting all the requirements? Of course, though I hold a 482 for the next. You have to meet the 190 491 requirements to lodge that visa. You cannot lodge a visa without meeting the requirements. Can I work with another employer as a casual as long as my 402 is not official yet? Yes, you can. Until your 402 is not granted, you can work anywhere, doesn't matter. And you do not have to work with an employer as an obligation. There's no such thing that if you're working, then only your visa will be granted. But after your visa has been granted, even if you're working 38 hours with the employer and you have got some free time to work somewhere else, you cannot. You have to and can only work with the same employer. Is area manager for cleaning company eligible for 482? No, there is no area manager in a 482 list. Is 2 years and 482 adequate to apply for TRT? That only depends on when you were holding a 457 visa before the Feb 18th, 18 March 2017, then only it's 2 years, otherwise it is 3 years. Once you have been holding a 482 visa for 3 years, then you are eligible. What are the work? And Abigail said, Preeti, hope you feel better. Thank you for that. What are the work requirements if I have been nominated or will go ahead for 482 visa from one employer and works as a casual for another? As I just said, no, it's not, cannot be done. So you said with the new concession in terms of working concession from Feb to December, though my 482 is still not official, the employer will process it soon. I'll be reaching 2 years experience soon this July. Can I go straight to 186? Is that clear? Okay. Now to go on to the 186, whether you have worked with the same employer or not doesn't matter. You only need to have the 3 years of a full-time experience. Or if you're talking about a 186 TRT, then either on a 1482 or on a 2482, which is combined with, let's say that you were on a short-term 482 visa, now and you have worked for 2 years, now you have applied for another one, and once you have gained 3 years of an experience and your second 482 has been granted, then you can apply for the 186 TRT. As a holder of a bridging visa, you will not be eligible. Your second 482 must have been granted in order to apply for the 186 TRT. Mary, again, to be granted any PR in terms of English language for spouse, I'm aware they need to have functional English, but what happens if they can't get functional English? Then you can apply the second VAC, which is approximately $5,000, which is to be paid at the time of a decision of a visa application. Okay. My employer has been approved as a SPS for 482. I have not applied for 482 nomination through them as I'm now eligible for 186. Does the employer have to apply for SPS? No, there is no SPS required for a 186. The 186 only have got 2 stages, which is nomination and visa. What are the caveats of accountant for 186? There's a caveat of minimum 1 million turnover and full-time employees as a 4-1. Is that 5 employees with the casual employees okay? Yes, that's fine as long as they are number of 5 employees. If I'm an accountant and eligible for both 190 and 186, which one should I prefer for a quick approval? The processing time of 190 for a decision-ready application is 4 months and 186 about 5 to 6 months. So they both are similar. You could apply for both. For TRT, it is a longer processing time. So if you are talking about a 186 TRT, then I would advise you to go with 190. And also for a 190, you have got an obligation to stay with the same state for 2 years. And for 186, you have got an obligation to stay with the same employer for 2 years. So you could see which obligation you wanted to meet for. Divyanshu, my employer will sponsor me in the next year. Will this rule still apply in the next 1 or 2 years? After I receive 4827 in 2023, will I be eligible to straight? So I just mentioned that in 2023, so you're going to get, and your 3 years are going to be finished in 2026. They could change this thing anytime because there is right now they have said it's a concession period and that can end as per the date which will be announced by the minister. So we don't have the date yet. We hope that this will go up to 2025, which is the 3 years from now, but we can't say up to 2026. We are currently in 485 visa. My husband is working in a restaurant from last 3 years as a full-time. Can we apply for a 482? Yes, you can, because for a 482, you only need 3 years of 2 years of an experience. Even you can apply for a 494 also and can have this one. If you apply for a 482 and can have the provisional permanent residency because he has got a 3 years of an experience. This 482, if you apply now, you can lead towards the 482 186 TRT also, provided you were in Australia during the February 2020 and December 2021. If you are, then if you apply for a 482 now, which is under the short-term list, those you can still apply for the TRT. And after how long you will be eligible for 186, I just answered that. Does 186 direct entry 3 years experience is a post qualification? Yes, it has to be a skilled experience. It is post qualification, full time, minimum 35 hours per week. For 494 experience should be post or pre qualification. It is again at a skilled level. So your duties which you have been undertaking, that is considered a very looked very briefly into it. My employer, Ajay Singh, my employer is sponsoring me for 482 in March 2023. I'll finish my 2 years experience in March. Can I apply for 186? As I just said, in March 2023, your experience is going to finish. Your TRT, you will be eligible in somewhere in June, July 2026. So the minister can end the concession period anytime. They have said that it will go up to 2025 and then they will decide again whether that can get extended or not. So it all depends upon the skill shortage at that point of time. Can we apply both nomination and 186 visa at the same time? Yes, there is no such requirement that the nomination must be approved in order to lodge a 186 visa. You can apply both together and you can get a bridging visa. It was said that employee must have worked for at least 3 years for a sponsoring employer while holding 482 to apply for 186. What about those who are permanent employee holding a different visa, subclass 500? So as I said, for a direct entry, you need to have a 3 years of an experience, whether you have worked with an employer or not, doesn't matter. Okay, that is only under the TRT where you should have worked for 3 employers with your 3 years with the sponsoring employer. That is only for a case for a TRT. For a direct entry, it doesn't matter. Mohammed Wakas, currently I'm working as an accountant for 3 months in NT. Before that, I was working as a production support officer in a construction company for 2 years in Melbourne. Am I eligible for TSS visa? So construction company manager, that's under a 2 years list. Yes, you could apply. If you apply now, you could be, because even if it's a short-term list, you still be eligible for the TRT after 3 years. I'm 27. I have been working in Australia as a support worker as permanent job in the last 4 years, and I have been on a student visa. Can I apply for 482 NAMA as the employer want to sponsor me? They're willing to apply for another visa, but I'm still on bridging. On a bridging visa, you can still apply for a 482. You need to be holding a bridging A, B, C, or a substantive visa, so you are eligible. If your employer is under a DAMA region and your position is available in DAMA, you should and must go with an endorsement and apply for this. Is social work under the DAMA list? The DAMA list is separate for every region, and you need to look into all the regions too, depending upon what region are you in. And yes, there are few Damas which has got a social worker. Purnima, we are currently in 485 visa. My husband is working in a restaurant from last, I think we have already talked about it. Wish. If my employer sponsors me on a 482 short-term list later this year, do I need 3 years of a work experience after my 482 is granted? Or my overall experience? No, your 3 years with the employer needs to be counted to apply for the TRT, not overall. If it was an overall, then every applicant will be eligible to apply for a TRT just after 1 year of holding a 482, because then you have got a total of 3 years. If you want, after total of 3 years, you want to apply for any visa, you can be eligible for a 494 visa, because that only needs an overall 3 years of an experience, not with the same employer. And that 494 will later apply, got you the 191. Do we have to stay working for an employer after 186 direct entry? It is just an obligation. It is not a condition, but Unless until it is mutually agreed, we will not advise. Is Accountant General under short term? Accountant General is under a long term list. Application EOI is totally free. Oh, sorry. One of the conditions for the 186 direct entry pathway is to have a license membership registration. I'm an accountant with 3 years of an experience and have my experience approved by CAA and NSZ and have student membership. Do I need to be qualified chartered accountant? No, accountant is not a registered this one, so you do not need to have a registration or a license in order to be eligible for 186. As long as you get a full skills assessment and 3 years of an experience, then you are good. Mohammed Wakas, I want to apply for visa. Would you be able to assist me for that? I want to start my visa process. Mohammed, we will get in touch with you. You can get in touch with us in the Perth office and book an appointment for, and you can mention about that you had gone on to this seminar today, and the consultation will be free. Full skills assessment is required for 186. Only for a direct entry, you need a full skills assessment. For TRT, no skills assessments is required. How to contact Preeti? Please call at the Perth branch. I will type down the number here and you can get in touch with us. Our Perth office number is 08 921 3020. All right. Thank you, guys. I guess this is the end of the questions today. And thank you so much for having the patience and listening that to me. Sorry for my voice today. I was a bit sick, but I don't want you to miss this. So I was here today. Thank you, everyone. Have a lovely day and be in touch. Thanks.